this is basically a summary of the arguments that have been presented in the Supreme Court on behalf of the petitioner. Here's the operative portion that Mr. Vishnu Shankar Jain was actually elaborating on. I'll just take you through it. It says the statutory provisions provide for the following twin requirements to be made before proceeding with the prosecution against an accused under the Unlawful Activities Prevention Act 1967, the UAPA. Section 45(1) Clause 2 mandates that no court shall take cognizance of an offence under Chapter 4 and 6 without the previous sanction of the central government or the state government, as the case may be. Then Section 45(2) of UAPA requires that such sanction under Section 45(1) shall be given within the prescribed time only after considering the report of such an authority appointed by the central government or the state government, as the case may be. The authority is required to make an independent review of the evidence gathered. So these twin conditions had not been met by the NIA before proceeding to file a charge sheet in this particular case, and that's the reason why the petitioner believes that the trial is infructuous, something that he claims now has been upheld on the part of the Supreme Court. We'll also, of course, wait for the Supreme Court order to be out.
All right. So we have Swapnil Kothari joining us on the phone line. Swapnil Kothari, big update coming in from the Supreme Court. It has stayed the trial against one of the key accused in the Malegaon case, Sharad Kulkarni, and it pointed that there was no sanction for prosecution by the central government under Section 45 of the UAPA Act. How do you look at it, and if you could break it down for our viewers?
Sagarika, I think what the court is trying to say is that when there is a certain procedure that has been stipulated under the Act, you need to follow that procedure as the investigating agency. If you have not followed that procedure, that means you have been a little over-enthusiastic in prosecuting. Now, all that enthusiasm is appreciated by the court at the end of the day, but nevertheless, you have to follow the letter of the law. If the sanction of the central government had to be obtained, and if the other condition that Siddharth pointed out needed to be done, then that is something which the NIA ought to have done. What was the big hurry? Heavens were not going to fall. Now, on that pretty technical ground itself, the petitioner has succeeded.
Right.
Now, one more thing for the benefit of your viewers is that the procedure has not been followed. So one should not be very happy about that fact as a petitioner that, I have succeeded to that extent. Tomorrow, the investigative agency will take a cue from this and say, okay, well, fair enough, we have not followed the procedure. The substantive portion of my FIR or of my case still remains valid. It's just that I have not been able to canvass it before the court because I have not followed a certain procedure. Say, for example, if a photocopy of my petition was wrong or was not clear, then the registrar would say, "Pehle photocopy ठीक कराइए, बाद में हम आपका petition admit करेंगे."
All right.
So that doesn't mean कि आपका petition infructuous है. इसका मतलब ये है कि आप ये ठीक कराइए.
All right.
Now, nothing stops the investigating agency from rectifying these two small errors on their part. These are not big errors. These are small errors, in my opinion, because I'm sure the investigating agency will go ahead to the court and say that, look, we've rectified this now. We've sought the permission, and now we are coming to you before yourself. To wherever before the trial court, etc. That they'll go. They'll not go before the Supreme Court.
All right.
They'll go before the trial court.
Yes. So, Mr. Kothari, you've given us a very detailed legal perspective on it, talking about the technical aspect of it. Thank you for